Imagine this. You wake up in the morning and you go through your regular morning routine. You go to the mailbox and you see that there is a letter-sized envelope in it. You open the envelope and you realize that you've now been served with a plaintiff's claim. Your thoughts immediately. What to do next? Hi, my name is Andre and I am a licensed paralegal in Ontario. In this video, I'd like to walk you step by step through how to handle this document properly and how not to lose your case before it even starts. Now, before we move on, I have to mention that this video is not a legal advice, and if you're looking for one for your particular situation, I would suggest reaching out to a licensed professional. The first and the most important step that you can take is rather simple. Just don't ignore the claim. If you fail to reply within the required time, then plaintiff can request what's called a default judgment. That means that the court may issue a decision in their favor without even listening to your side of the story. For the next step, let's take a look at the plaintiff's claim document and what it looks like. At the top side of the document, you can find the information about the court's jurisdiction, the address, and at the top right-hand side, the claim number. It is followed then by the information about the plaintiff, such as their names, whether it's an individual or a company, their address for service, and whether they're represented or not. Be advised that, generally speaking, if the party is represented, you're not allowed to reach out directly to them and instead have to do it through their representative. So, what are the key takeaways from this page? First, it is the court claim number, and secondly, it's the name of the parties to the claim and their address for service. You will need this information for every step going forward, so it is good to have this information accessible. The next step is to determine your deadline to respond. Earlier, I've mentioned of the importance of filing your response within the required timeline. But what is the timeline? Many things, including claims and response to them, are regulated by specific rules set out by the court, and small claims court is no exception. As such, there is a rule that says that you have 20 calendar days to file your defense. But how do I calculate those 20 days? Oh, the answer is simple. Just follow another rule. The rule says that the calculation shall exclude the first day on when you have been served, and you start it from the next day, and if the last day falls on the holiday, then you should take the next business day. So let's take an example. If I was served on Monday, March 30th, then we exclude this day and we start counting 20 days from March 31st. That takes us to April the 19th. But April 19th is Sunday, which is also considered a holiday with the courts. So we go to the next business day, which is Monday, April the 20th, and this is our deadline. As a note, I would suggest just putting a calendar note and setting a reminder a couple of days in advance so that you don't miss it. As I've mentioned, it is quite important to file on time, and missing the deadline can have serious consequences. But before you respond, you have to carefully review and understand what is being claimed. You can do so by taking a look at pages 2 and 3 of the plaintiff's claim, as well as any attached schedules and supporting documents. It is on those pages that the plaintiff explains their side of the story, what they believe has happened, why they believe that you're responsible, and the amount that they are claiming. Take your time reviewing this document and be sure to get a proper understanding what they're claiming before deciding how to respond. Once you understood the claim, now you can decide the direction that you'd like to proceed. And it is at this stage that seeking legal advice can be very helpful. Generally, you have 3 directions. You may agree with the claim and admit responsibility. In this case, you can just put forward a payment plan. You may disagree with the claim and file a defense to dispute it in the court. Or if you believe that the plaintiff themselves is responsible for some damages, you can file what's called a defendant's claim. Now that you've chosen your direction, you have to start organizing your case immediately. Create a folder, whether physical or digital, and start gathering evidence. Those could be emails, text messages, videos, invoices, contracts or agreements, or any notes from the time of the dispute. All those things matter, and the more organized your evidence is, the more solid your position will be. The claim is a structured process where each step depends on your previous choices. So, depending on the decisions done previously, the next step can be either a terms of payment hearing if you've agreed with the claim but the payment is being disputed, or a settlement conference if you disagreed with the claim and filed the defense. On settlement conference, parties meet with a judge and see if the matter can be resolved. Court proceeding can become expensive and time-consuming endeavor, so the purpose of this step is to see if the issues can be clarified or if the matter can be resolved without going into trial. A few practical points to keep in mind. First, consider seeking legal advice early, as even a single consultation can help you understand your position better. Keep communication professional and focused. Try to avoid any emotional or unnecessary exchange. And finally, stay organized. Keeping your files and timelines structured will save you time and will make every step down the line easier. Okay, I know it's been a lot of information, so let's try to sum it up in a quick checklist. So, if you've been served with a plaintiff's claim, here is the checklist of what you have to follow. The first step is to do not ignore the claim. The second step, identify that it's indeed a small claims court proceeding. The third one, identify the plaintiffs and the claim number as you will need it down the line. The fourth, calculate your deadline for response. 5. Read and understand the claim carefully. 6. Decide on your strategy, because it will impact your next steps. 7. Start gathering evidence and organizing your file. And 8. Prepare for the next stages in the process. And remember, with the claim, the preparation is the key. If this video helped you better understand the process, please feel free to hit the like button and subscribe to my channel. If there is a topic that you'd like to have covered next, feel free to leave it in the comments down below. Thank you for watching, and here is a quick tip for the day. Recently, the monetary limit for the matters in small claims court has been increased from $35,000 to $50,000, which means that there are now more matters that are being decided at this level. Again, thank you for watching, and we'll see you in the next video.